day in San Diego. So hopefully this is a good day for a Zoom lunch. My name is Todd Neal. I am a partner with the Procopio law firm. I handle business litigation matters and defense of government actions such as SEC enforcement actions. I've been practicing for 29 years. I've had about 40 jury trials, and I'm joined today by my colleague, David Gazulis. David is a young lawyer with our firm. He's been practicing for about 8.5 years. He joined our firm recently. He previously was with Alston and Bird in Atlanta, New York, and Los Angeles. David also has trial experience in commercial disputes. So our title today is Superhero or Villain: How to Prevent Executives from Saying the Wrong Thing When Testifying. We thought of our title in response to a lot of bad testimony that we've seen in recent high-profile litigation involving people such as Elizabeth Holmes, Elon Musk, Johnny Depp, and Amber Heard. We've seen lots of bad testimony that's been hurting cases. And we thought it would be just kind of a fun presentation to talk about things that you can do to prepare executives to testify as effectively as possible. Now, admittedly, there's no way to absolutely prevent a witness from saying the wrong thing when they testify. Sometimes, regardless of the quality of the presentation or the preparation that's been done, a witness still will make a serious mistake when testifying. But what we'd like to talk about today are just the things that you can do to lessen the chances of that happening. We've added some video clips, cartoon or two, just to try to add some levity to it. The videos, as is often the case, seem to each one has a different volume level, so you might need to make an adjustment on your volume when a video clip starts to play. I think one of the reasons, at least in my view, that this is an interesting topic is giving testimony is a very different exercise than a typical day in the life of a corporate executive. Corporate executives tend to decide, when a meeting is going to occur, what the meeting is going to focus on, who's going to attend, when the meeting is going to end. And giving testimony obviously is a very, very different process than that. And when we talk about C-suite executives, we have to remember that the C stands for chief. Chief means a leader or ruler of people, but when they go on a witness stand, they don't get to lead or rule. And a lot of times the qualities that helped an executive ascend the corporate ranks to the top can backfire and make them a poor witness. They're usually not accustomed to having their motives, competency, or ethics challenged. And how they react to that when they testify is critical, whether it's a deposition or at trial. And the reason it's critical is because the CEO is literally the face of a company. And many jurors believe that the CEO is a reflection on how the company treats their employees, how they treat their customers, whether they honor their word, whether they care about safety. And I think all of those things mean that the stakes are high when an executive has to testify. So it's very important that a really high quality preparation job be done before the executive takes the stand. So most of our comments today are going to be directed toward cross-examination. But of course, extensive preparation is also needed for direct examination. But I think what makes cross-examination so uncomfortable for a witness is the unknown. Will the questioning attorney come out swinging? Or will they take a softer approach? Will they try to bully the witness? Will they try to trick the witness? And providing testimony is not easy. You're essentially put on a witness stand as the face of a company trying to convince strangers, a jury, about the merits of a claim or defense. So the witness is really thrown into the fire when they're put on the witness stand in a trial. The only way to get through that experience is to prepare extensively with an experienced trial lawyer. I think you have to methodically talk through your primary case themes, all of the subpoints that support each of your case themes. You need to talk through the likely lines of attack on cross-exam by opposing counsel. I think it's also very critical to do a very thorough review of the important documents with all witnesses, in particular corporate executives. And I think from a trial lawyer's perspective, one of the worst things that can happen is to have a witness be blindsided by something that is contained in an important document that you didn't prepare the witness for. A good trial lawyer just can't allow that to happen.
Thanks, Todd. So I'm going to talk a little bit about demeanor and temperament. Anybody who's been in a courtroom or watched courtroom drama on TV or movies knows that when an important person is on the stand, and here we're talking about an executive, it's not just the words that they say and that might end up on a trial transcript. It's really how that person comes across, how he or she comes across to the fact finder, whether that's the judge in a bench trial or the jury in a jury trial. And so that's another key part of preparation, because the executive needs to keep in mind that they're not talking to shareholders or a board of directors or their chief operations officer. They're talking to jurors, people who have possibly very little in common with the executive. And so it's important that the executive come across as down to earth and relatable, which may not be 100% possible, but it's good to get that theme across to the executive so they can kind of put on that face when they're testifying. It's also very important that the executive not talk down or be patronizing to the jurors who may be kind of mindful themselves watching this person of either incredible intelligence or wealth or both testifying. It's important that the jurors find them relatable and they don't think that they're being talked down to. One specific issue is eye contact, and there's plenty of schools of thought on this as to whether the witness who's testifying should make some eye contact with the jury box or the judge as they're testifying, whether that should be constant as in every answer. What the approach that Todd and I generally recommend is that it's occasional eye contact is important if you're giving an answer, to look over and engage with the jury, but not to stare at them the whole time, because then that ends up being a little more awkward too. As far as cars and flashy jewelry, there's kind of a colloquialism of, don't drive the Ferrari to the courthouse that day. And in some jurisdictions or in some courthouses, or if it's a bench trial, that isn't as important, but there's plenty of courthouse setups. For example, the courthouse in Vista here in San Diego, that's a very big parking lot where you could easily have an executive pulling up in a car, walking right in with a juror who happened to park in the exact same parking lot. And particularly if there's issues of unjust enrichment or that type of theme in play, opposing counsel could exploit that. And you do not want to have your executive drive, the yellow Ferrari parked right next to the juror in a Toyota Camry. It just sets up a bad dynamic from the get-go. So we'd recommend to leave the sports cars at home, and also flashy jewelry too. That's not to say that he or she can't wear a watch or earrings or a necklace, but just try to keep it reasonable so that the fact finder, the jurors, don't look over at the witness box and think, my God, I wonder how much that costs. That's not the thing that you want to have going through the juror's head when they're listening to the executive testify. The second bullet here is executives must avoid lashing out or treating opposing counsel with condescension. And it's important, litigation takes a long time. You might have several years of backdrop of nasty discovery disputes, or maybe a testy deposition between the executive and opposing counsel, but the jurors aren't going to know any of that. And so, the executive might think that cross-examining opposing counsel is the worst person in the world, but it's important that there's still a treatment with respect, and we have to pretend that that backdrop isn't there, because the jurors aren't going to know that. And the more cold and standoffish the executive is, that's just going to look worse for the executive and ultimately for the company in the trial. And so if opposing counsel tries to spar with the executive or get under their skin, either with a raised voice or with very pointed, maybe even a rude line of questioning, everything that the executive can do to not buy into that and retaliate not only makes the executive look good, but it also makes opposing counsel look bad. So it's a 2-for-1.
I think so much of how an executive performs on the stand really starts with the relationship the executive has with the trial lawyer. When I think back on the trials that I've been a part of, in situations where I had a very comfortable, good connection with the executive who was going to testify, I feel like almost each time that witness performed much better than the few circumstances I've had where I had an executive witness that I really struggled to develop a connection with. I think creating that level of comfort, confidence in one another, and a sense of teamwork and working toward a common goal really has a big impact on how an executive does when they take the stand. So I think it's really up to the trial lawyer to approach that relationship in a way that leads to a good personal connection and a good feeling that the witness can trust the lawyer. The witness feels that the lawyer is very well prepared, that the lawyer is on top of the case, and that the lawyer is giving the witness appropriate advice. And I really think it starts with how the lawyer conducts himself in the initial meetings with the executive. I think it's important to be positive, to be upbeat, to be warm, to be appropriately confident. We all know there are lawyers out there who are not the warmest in terms of personal interaction. And I think that's difficult to have a situation like that when you have a very long relationship going through a lengthy pretrial phase leading up to trial, and there really hasn't been the development of a good personal connection between the trial lawyer and the executive or executives who will be testifying. And I think the energy and the overall kind of aura that the lawyer brings to the relationship is so important. I think it's important for the lawyer to be authentic, to be sincere, to be very prepared, and without flouting it in a deliberate way. Just make sure that the client feels comfortable that the lawyer is on top of the facts, on top of the key legal issues in the case, aware of what the pitfalls in the case might be, and has a clear path to victory that the lawyer is able to communicate effectively to the client and all of the witnesses associated with the client. I think having that connection, and I think it's important to try to connect on something that's unrelated to the case, whether it's baseball or kids or where a person's from, just to establish some personal rapport has a huge impact on the trust factor and the willingness to have an open dialogue. And that open dialogue is really critical, because only through an open dialogue can the trial attorney develop a clear understanding of the client's perspective and the client's goals in the case. I think it's always important when you're dealing with business people as clients that you make sure they're aware that you're very focused on the right business solution for this particular case. To not give that sufficient attention and to get carried away with legal issues and different nuances in terms of how arguments can be made. I don't think that is the right approach to developing that strong bond with the executive as a witness. I think the executive wants to know that you understand their business, you understand how it operates, you understand how they make money, you understand what their goals are for the future, and your case strategy is modeled in part to help them continue to achieve their business goals. Another reason the open dialogue is really important is there will be things that are not clear from the documentary record, and there's a wide range in working with a client in terms of how much of that non-documented information the lawyer obtains. The better the relationship, the more open the dialogue, the more of that information the lawyer will get. And I think, when you look at the key documents in a case, a lot of times, getting some of the anecdotes that go with, when a particular provision was negotiated, which party was pushing for what aspect of it to be documented and in what form. It really adds a lot of context to the lawyer's understanding of the case, the dispute, and it often allows the lawyer to ask much better questions, not only on direct, but also when the adverse witnesses are questioned on cross-examination. I think it's important for the trial lawyer to explain to the executive witness the context of their testimony and how it fits into the case. Go over the claims that are at issue, the legal framework under which those claims are being decided. I don't think it needs to be a lesson in civil procedure, but it's important to communicate to the client what there's basically 4 stages to litigation. And it's important for the client to know what's going to happen in each stage and how it is that their testimony fits into the case. I think to get a fully engaged witness, you have a much better chance of having that happen when you've made it clear to the executive why their role in the case is important, why the testimony that you need to get from them is important, how it's going to affect the ultimate outcome, and why they hopefully will agree that they need to pay close attention to what's going on in the case. I personally like the idea of having a series of meetings with an executive witness as opposed to a single marathon session. I think it's good to start with a meeting where you do more listening than talking as the trial lawyer, and you ask open-ended questions. You allow the executive to talk freely and get things off their chest they need to get off their chest, to tell you, what they think is unfair about the fact that they even have to deal with the case, what their ultimate hope is for how this is going to be resolved. I think it's very important for the witness to feel like the lawyer is really listening and developing strategy based on the client's wishes. I also think when you start with some initial meetings where you're allowing the witness to do most or a big percentage of the talking, it makes it more natural when you get to the later meetings, when you're doing actual witness prep, when you want to tell the witness your instructions on providing really disciplined answers to questions, where you want to drill down on the general approach to testifying, which is really concentrate on what the question is asking. Consider your answer before you start talking. Generally, you want to answer the question in the shortest, truthful way possible. I think having that discussion after you've gone through the process of having some very free, open discussions with the executive is a much more comfortable, natural way to prepare the witness. I think to walk right in at an initial meeting and start talking about, I want you to say very little. I want you to give yes or no, or if you don't know, don't guess. I think that is sort of out of context until you've gotten to know each other a bit and learned what the executive can contribute to the case. I think to get an executive witness to perform well on the stand, you really need to approach the process of preparing the witness as an exercise in instilling confidence in that witness. Of course, the more comfortable a witness is, the better job they'll do testifying, as opposed to a witness who is kind of on edge, kind of unsure of their role in the case, not really clear that the lawyer understands their business objectives. I think that's a very difficult way for a witness to take the stand. And I think the general approach really needs to be done through a process of letting the witness be heard, demonstrating your competency, demonstrating your humanity, your willingness to listen and hear out what they want to tell you before you start giving them specific instructions in terms of how their testimony needs to go. And in order to do that, I think a lawyer needs to be very well prepared even before that initial meeting with executives. You need to show that you're on top of the key facts, that you're aware of the determinative legal issues in the case, what the case law says, any statutory law that's relevant to the outcome of the case. I think it's also very comforting for your witness when you can educate them on the key players in the situation. The judge's background, judge's tendencies, judge's reputation. Same thing with the opposing counsel, what you know about their practice, what you've learned from your partners or other lawyers, what you know about their trial skills, their willingness to go to trial. I think all of that really makes an executive witness feel much more kind of on the inside of what they need to know before they put themselves in a high risk situation of being a witness. And again, I like the idea of scheduling shorter meetings to start instead of a marathon session. The marathon sessions the day before a deposition are always bad. Attention fades after a couple of hours. It's just too much to take in for a witness the day before a deposition. You end up with a stressed out, tired witness when they show up for their deposition. And I'm a big believer in starting the preparation weeks in advance of any testimony. I think it's also important to explain to your client why they need to avoid keeping secrets from you. There's a reason the attorney-client privilege exists. And if you're not told things that you need to know as the trial lawyer and you get blindsided, it can be absolutely devastating to your client's case. And I think it's important to make sure that your client fully understands that. I've had lots of cases with sophisticated clients where they still seem to think there are things they should hold back from their lawyer. And it's never a good idea. Strategy can be adjusted based on information that's shared. But if information is not shared and you learn of it on the fly in trial or in a deposition, there's very little that you can do to respond to it and deal with it in an effective way so that it doesn't harm your case.
All right, so now that we've given a bit of an overview kind of the general executive testimony landscape and preparation, we're going to move into a couple specifics of what we'd say are probably the key 5 or 6 takeaways and most important pieces of advice that we give to executives when preparing them and that we are giving today. So you can see here on slide 6, the witness is being cross-examined by a classic pinstripe suit, very aggressive opposing counsel right by the witness stand, and his nose, just as Pinocchio's does, has lengthened, and the judge seems to say, perhaps you'd like to reconsider that last answer. Tell the truth is the most important rule of testimony that goes for whether the witness is testifying in a deposition or at trial. As Todd said earlier, the executive really is the face of the company. There's going to be plenty of witnesses probably, but this is the chief executive officer or some other very high up executive. And if that person can be shown to have testified falsely, then the case really will fall apart. And bullet point 2 here, give the shortest truthful answer possible, then stop talking. That is, there's a bit of a distinction between deposition prep and answers and trial prep and answers. So for a deposition, as many of you know, the shortest, most truthful answer possible and then stop is a great piece of advice, because you're not going to be scoring points at a deposition as the witness. You are just hoping to minimize the damage done to the case, and you do not want the witness to offer up anything that they don't have to. At trial, though, when there's a jury or the judge who's weighing the evidence and testimony that comes in and making the decision as to the case, you don't want the witness to look like they're just giving a one-word answer every time and then stopping. It looks a little too cheeky, and it looks like the witness either doesn't know anything, which isn't good, or is being deliberately evasive. And neither of those are good. So just note for number 2 there is a bit of a distinction between deposition testimony and trial. At trial, the witness should be a little more engaged, a little more open with testimony, but obviously not 5-minute narrative answers either. The next bullet, life is not a box of chocolates. We're not talking about Forrest Gump here. We're going to give a little metaphor. So if you think about a nice box of chocolates that you get for your mother-in-law from C's Candies, and you open up and she takes a bite of one of them and there's a maggot inside of that piece of chocolate, you're going to throw that piece away, and then there's still maybe 11, 10 other pieces of chocolate. But do you think the person's going to go back and eat another piece of chocolate out of that box? Probably not. And so we're going to apply that same principle, and fact finders do, to executive testimony. And so if the executive is shown to have testified falsely with respect to one issue, it's very likely that the jury is going to disregard or find false a lot of the other testimony that the executive gives as well. And in fact, judges will often give a jury instruction to that effect. If you find that the witness is not truthful with respect to one issue, you may disregard that witness's testimony as to all issues. So falsus in uno, falsus in omnibus is the same principle. Lastly, never speculate or guess. This is key. And this brings in a point of trial that some of you may know, some of you may not. The witness usually is going to be sequestered and will not know what testimony has been given before, what testimony might come after them, what documents the jury has seen already, or what documents the jury might see after the witness's testimony. And so if an executive is speculating or guessing on the stand, that opens up the possibility for a contradiction with previous evidence, or something that a later witness could say. And that goes back to an earlier point about plausibility and truth. If the executive is on the stand and says, well, I'm sure Sarah in our finance department would know that, but Sarah might have been on the stand 2 days ago and said, well, actually, that's what our chief executive officer did. So that would just, that the case falls apart at that point. So it's important that the witness not speculate or guess as to anything, but still, as always, tell the truth. So we're going to move into a little video segment. As Todd said at the beginning, you might need to adjust your volume. I'll try to do it on my end. So this, I'll play it first and give a little bit of color commentary.
Congressman, cigarettes and nicotine clearly do not meet the classic definitions of addiction. There is no intoxication.
We'll take that as a no, and again, time is short. If you could just, I think each of you believe nicotine is not addictive. We just would like to have this for the record.
I don't believe that nicotine or our products are addictive.
I believe nicotine is not addictive.
I believe that nicotine is not addictive.
I believe that nicotine is not addictive.
And I too believe that nicotine is not addictive.
So as you can see, this lineup of tobacco executives in a Senate hearing in the late 1990s all testified adamantly that nicotine is not addictive. And although this was a Senate hearing testimony, they're still testifying under oath. And there were several trials right around the same time period as well, in which tobacco executives also testified in these trials that cigarettes and nicotine were not addictive. Now, you could argue there's a distinction between the executives saying they believe it's not addictive versus them stating it as a fact. But just imagine that you were a juror as late as the late 1990s, knowing what was known then at the time about the addictive qualities of cigarettes and nicotine, and hearing that from the face of the company, the corporate executive. It just doesn't pass the smell test, and then all the credibility, all the testimony, can be disregarded and goes out the window for the witness. Our next slide, we can't really give in good faith a trial webinar without talking about Amber Heard and Johnny Depp right now. So these are obviously not corporate executives, but just like in a corporate executive testimony context, really this trial came down to Johnny Depp on the one hand as the face of his case and Amber Heard on the other as the face of her case. Ultimately, I believe Johnny Depp was awarded maybe 15 million or so of damages in his defamation suit. Amber Heard, according to the talking heads and all the pundits, was caught in some lies on the stand and just generally did not come across as believable or credible to the jury. And so I've got a bit of a clip here that I'm going to play, and hopefully you can hear this, but not have the volume be too loud.
Quote, $7 million in total was donated to, I split it between the ACLU and the Children's Hospital of Los Angeles, end quote. Right?
That's correct. I made that statement as soon as I got a divorce and we reached the settlement. That's when I pledged it, right then. And
you say this because you, quote, wanted nothing, end quote.
That is correct.
But you hadn't donated your entire $7 million settlement to charity at that point, had you?
That's incorrect.
Sitting here today, Ms. Heard, you still haven't donated the $7 million divorce settlement to charity. Isn't that right?
Incorrect. I pledged the entirety of the settlement, $7 million to charity, and I intend to fulfill those obligations.
Ms. Heard, that's not my question. Please,
what
try to answer my question. Sitting here today, you have not donated the $7 million, donated, not pledged, donated the $7 million divorce settlement to charity.
I use pledge and donation synonymous with one another.
So my understanding is that Amber Heard had testified and had documents also in which she claimed to have donated her entire divorce settlement with Johnny Depp, although in cross-examination, she's caught that she didn't actually donate that money yet. She just pledged to donate it. So, not a key issue in the case in as far as the defamation case, but credibility goes out the window. Here on slide 10, this is an excerpt from the trial transcript from the Tesla Solar City merger litigation, which was in 2021 in the Delaware Court of Chancery. And Elon Musk was the first witness called by the plaintiff in their case in chief. He was cross-examined, and plaintiff's counsel was making a point about Elon Musk, for all intents and purposes, controlling Tesla, even though he had said that in his role in the company, he didn't control it, it was a board. And so asked if the world sees him as controller of Tesla, Elon Musk said no. And then this next question is really where I think Elon Musk falters a little bit. He says, you don't believe that walking down the street, most anybody who knows Elon Musk and Tesla goes, yeah, Elon Musk controls Tesla. You're not aware of that. And he says, I don't think that's the case at all. And I think the better answer there is, well, I'm not sure what a layperson might think, but legally speaking, and as the company is structured, I don't control Tesla. But when you say something like, well, I don't think that's the case at all, that's, that doesn't come across as a true statement. So sticking with Elon Musk, we're going to move to a second point of trial preparation for executives, which is very, very important, which is to ignore theatrics by the questioner, and a skilled cross-examiner, as Todd hinted at earlier, might take a different tack with a different witness. Oftentimes, though, cross-examination is combative, either with the way the questions are asked or the literal words within the question, making an insinuation about the way the executive runs the company, something to that effect. And as we said earlier about demeanor and preparation, it is very important to not buy into that and get into mudslinging with opposing counsel, because that's all the jury is going to remember from the testimony. So the backdrop here is that Elon Musk was deposed earlier in this case and got into it with opposing counsel on the record. There was a lot of ugly back and forth about the Robbins Geller law firm and its predecessor firm, Milberg Weiss, and Elon Musk had done his homework and knew all of this about the firm. And he said really outrageous things about the opposing counsel. Well, that came up, of course, at trial. And Elon Musk at trial was testifying on the record that he did not respect opposing counsel, and then went so far as to say, "I think you are a bad human being." It didn't end up hurting Elon Musk and Tesla's case that much, because that was a bench trial before the Delaware Court of Chancery. But just imagine that a jury is hearing that instead. I don't think that would go so well for their case.
Thanks, David. Okay, we can't end the video clips without using the most famous movie example of a witness being baited by a questioning attorney. Let's see if you can handle this video clip.
Lieutenant Kendrick ordered the code red, didn't he? Because that's what you told Lieutenant Kendrick to do.
Object! And when it went bad, you cut these guys loose! Your Honor, you had markers inside a phony transfer. Your Honor, you doctored the logbook. Damn it, Captain! You coerced the doctor.
Consider yourself in contempt.
Colonel Jessup, did you order the code red?
You don't have to answer that question.
I'll answer the question. You want answers? I think I'm entitled. You want answers? I want the truth! You can't handle the truth!
Okay, one of the most famous trial movie scenes in history, I think. It goes on to talk about how Tom Cruise needs him on that wall. That was the great scene. So I want to touch a little bit on depositions. I think a really important thing for a deposition witness, especially an executive witness, to know is how deposition testimony is used at trial or can be used at trial. I think we all know that now virtually every deposition is being videotaped, and we've moved past the old days when if you wanted to introduce deposition testimony at trial, it was a very dry process of reading question and answer straight out of the transcript. And now it's very slick, it's very compelling. It's click a button and you can go right to a video clip showing questions and answers from a deposition. Many people think that that only really is used for impeachment, but that's not true. When you're dealing with a party deponent, you can use prior testimony under oath virtually for any reason. It just has to be substantive. So it can be introduced in a case in chief. It could be introduced through cross-examination. And because of that, when a witness gives deposition testimony, they need to know what can happen down the road if the case goes to trial. When a witness shows up in a deposition, you're in a conference room, of course, lawyers, court reporter, videographer. A lot of times it's a reasonably friendly setting where there's some small talk, and it can create a comfort level in the witness that perhaps can pose a problem during the course of the deposition. And what I always tell witnesses is that the deposition is being videotaped, but there's only one camera and the camera is only on you. And you can do a fabulous job for a full day of testimony, but if you lose your cool, even just briefly, and you give an answer or two that's a careless, angry, undisciplined answer, what will happen down the road is that's going to be thrown back in your face throughout the remainder of the case. And it can be a really bad look at trial if that video clip shows your witness acting in an angry way, a disrespectful way, hostile way. And it's a very unfair process in my view. You have a questioning attorney often with eye rolls and scoffs and different facial expressions communicating they don't believe what a witness is saying. But at the end of the day, none of that shows up on camera, and it's really only the witness that can be punished if they give into that and act in an aggressive way in the way that they testify. And I try to impress upon clients who are testifying in a deposition that you really have to look past the questioning attorney. You're not speaking to the questioning attorney. You're speaking, even though they're not there yet, to the judge and the jury. And the reaction of the questioning attorney is entirely irrelevant. It means nothing. And the exercise is just to listen to the words and really make sure that you understand the question. If you need to ask a question about the question, do it. If you need to qualify your answer, do it. If you need to say, I don't understand the question, can you rephrase that? Do it. But it's just very important for the witness to understand that the camera and the use of the videotape can end up being very significant at trial. I think another thing that's really important for a deposition witness to understand going into a deposition is just this concept of letting silence be your friend. What I think we've all seen at different times in depositions is you have a question asked and an answer is given, witness stops talking, the questioning attorney stares at the witness, there's a period of silence in the room, witness gets uncomfortable, witness starts talking again. And that generally leads to problems. It's very important for a witness to be comfortable with the idea that this is not a normal conversation. This isn't intended to flow back and forth. This is question and answer, one at a time. And when they've given their answer, conclude the answer, stop talking, and be very comfortable with however long the pause is, waiting for that next question to be asked, and then repeat the same exercise. Concentrate on the question, make sure you understand it, and answer it in the shortest, truthful way that you can. One thing I also like to tell witnesses is, even though they may not realize it going into the deposition, they actually control the pace of the deposition. It's not the questioning attorney that controls the pace. The witness has the right to consider their answer before they start talking. They have the right to answer it in the manner that they choose. They have the right to qualify the answer. They have the right to ask questions about the question. And the questioning attorney, I think a lot of times witnesses are worried it's going to be rapid fire questioning. It's going to be sort of berating. And that's what the lawyer is there for, representing the witness, is to jump in and prevent that from happening. But I just think conceptually, for the witness to go in being comfortable with the idea of silence and recognizing that they really can go at the pace that they're comfortable with, I think is very important. Something that is extremely important in my view when a corporate executive testifies is to be accountable, to properly accept responsibility for mistakes that were made, avoid blaming subordinates. Harry Truman, when he was president, had a plaque on his desk that said, "The buck stops here." And I think jurors, who generally are not CEOs of significant companies, sometimes they are, but generally they're not. They expect that mentality from company executives, that they are ultimately responsible for what's happening within their company. And it's important for executives to avoid passing the buck too much onto others or dodging responsibility, because jurors they really view that as a cheap shot and lacking in character by the company leader when they try to distance themselves from mistakes that were made. I think another thing that's important is it doesn't go over well when an executive tries to purposely insulate themselves from the truth. Willful ignorance does not equal plausible deniability. If something was available for an executive to learn about or to find out the answer to, and it's clear that they just chose not to do it so they could bury their head in the sand and profess ignorance on a point, that backfires for the most part and really doesn't go over well with the jury. A good example from the Elizabeth Holmes, this was actually her SEC testimony, not her recent criminal trial, but she was parsing and trying to distance herself from many of the improper things that were done at Theranos. And it reached a point where the SEC attorney asked her, so what were you responsible for? And her answer was, I was CEO of the company. I, from a technology perspective, was focused on inventions and named on a large number of patents. I tried to contribute creatively to technical issues when we were dealing with technical issues that would require invention. However you want to characterize it, that's evasive BS. And it never does well for the witness or for the company that they're with when the testimony goes in that direction. One minor exception to this concept, though, I do think it's fair to explain to a jury that depending on the size of a company, depending on different divisions of a company, areas of responsibility, it's not realistic to expect a CEO to know absolutely everything that's going on within their company. And in order to make that point in a non-defensive, constructive way, I think it's important to provide evidence and testimony about the company's structure and the divisions of responsibilities. And I think that should start an opening statement for the most part. And it's something that I think is critical to provide some context for the jury, just in terms of what's a fair expectation to have on the CEO of that particular company.
So to continue the same theme about evasiveness hurting the case, the more evasive and dodgy the witness appears, not willing to give a straight answer or being combative and overqualifying answers, it doesn't look good for the executive who's testifying. And in I believe it was the late 1990s, Microsoft was embroiled in some antitrust litigation with regards to its web browsers, and Bill Gates was deposed and his videotaped deposition testimony was played at trial, and the trial judge repeatedly shook his head at Mr. Gates's antics. He went so far as to claim he didn't know what a browser was, which, for anyone who knows the company and Bill Gates and his role and his intelligence, it's just simply ridiculous. And so ultimately the court ruled against Microsoft, found violations of Sherman Antitrust Act, and ordered that Microsoft be broken up. That testimony is available on YouTube in very large sections, so we couldn't pull it into this video. But if you're bored and want to look up Bill Gates's deposition testimony, it's comical how evasive he is, both as far as his body language. He's got some kind of weird tics going on. He doesn't give a straight answer pretty much the entire time. And speaking of being evasive, we referenced President Harry Truman earlier. We'll give a brief clip of a former President, Bill Clinton, during his televised grand jury testimony. And we'll try to play this.
Statement of your attorney, Mr. Bennett, at Paul Jones' deposition. The statement that there was no sex of any kind, in any manner, shape, or form with President Clinton was an utterly false statement. Is that correct?
It depends upon what the meaning of the word is. If is means is and never has been, that is not that's one thing. If it means there is none, that was a completely true statement.
So when posed a question and then is that correct, which is a common line of questioning, you might hear that type of phrasing in cross-examination. President Clinton then says, well, that depends on what the word is means, and you can see even smirks. And so this is just a good example of a very bad answer from a very important witness.
So just to sum up, I think just sort of an overview of what the approach needs to be with a high-level witness. You want to make sure they know and they understand the fundamentals of the case, but I don't think it's a good idea to try to get them to memorize the right answers. Answers that seem rehearsed are of course less authentic, less credible, and I think it just puts too much pressure on a witness if they feel that they need to phrase each answer absolutely perfectly based on the way they've prepared to testify. I think it's important to do practice runs through the direct exam and also do practice cross-examination. But your goal really should be to have the witness go on the stand with 3 to 5 basic goals or case themes in mind when they testify, and then just to be free to concentrate and think through their answers and answer the questions in the best way that they can. I also think it's important to practice testimony, and if you've got a case that's going to trial, I think it should be in a courtroom or a mock courtroom, and they should get the feeling of being on a witness stand. We have a mock courtroom at Procopio that we use specifically for that purpose. I also think that for mock cross-examination, it should not be the trial lawyer doing it. I think it should be a colleague of the trial lawyer who is given a script and is prepared by the trial lawyer to do the cross-exam. But I think it really makes the relationship, it can be a little awkward after you've done a really aggressive cross-examination on the client that 5 minutes later you'll be patting on the shoulder and telling him that the case looks great, or telling her that the case looks great and that they are doing a great job with being ready to testify. So to conclude, preparation is key. You've got to tell the truth. Important to disregard theatrics from opposing counsel. They need to understand the importance of deposition testimony and how it can be used. Don't be evasive. Give straightforward answers. Don't play games. Don't try to memorize the script. Just understand the basic goals and the case themes and try to incorporate those through your answers as much as you can. And I really think at the end of the day on this issue of doing a good preparation job for an executive witness, so much of it depends on the trial lawyer and the way the trial lawyer handles the interaction with the witness and all of the work leading up to the trial. Does the lawyer convey that they're on top of the case in a calm way that doesn't convey anxiousness? Has the lawyer made the witness feel comfortable that they know what's coming on cross-exam? Does the witness feel confident in the lawyer's ability to present the client's case? I think that's a critical part of the witness being comfortable when they testify. If they take the stand and they're not sure they've got the right lawyer, or their lawyer's not adequately prepared to effectively present the case, that's an extra burden on them when they take the stand. So I think, one of the great things about being a trial lawyer, in my view, is everything you do in a case, really from the start of a dispute, is an opportunity to advance your client's cause, to create confidence in your client, your witnesses, to be persuasive and be effective in advocating your client's position. And that's each phone call with opposing counsel, that's each email to the client, that's each court hearing, even if it's a status hearing. the approach, always needs to be with the case goal in mind, how you're going to get along that path to victory to win the case. And if your client sees that, your client becomes comfortable with that, it's going to make their job in testifying a lot easier. I thank you very much for listening today. I see that we're a couple of minutes from 1 o'clock. We could take a question or two if anyone has a question. But thank you very much for being with us today. So any questions? Okay.
Silence is your friend.
I think that silence is our friend, as we said. Okay, well, enjoy the rest of your day, and please feel free to contact us if we can ever help you on a litigation matter. Have a good day.
You have a chat box. Oh, all right. Yeah, we're good.
Okay.
Okay. Thank you.